What unfolded inside a federal courtroom today was not just another dramatic moment in Donald Trump's legal battles. It was a complete breakdown of courtroom order, so severe that a federal judge lost patience and ordered Trump's own lawyers removed from the proceeding. This was not symbolic. It was not a warning. Federal marshals physically escorted senior defense attorneys out of the courtroom, while the judge threatened bar referrals on the record. According to multiple courtroom observers, the atmosphere was already tense before the incident began. Prosecutors had signaled earlier in the week that a key piece of evidence was about to be introduced, something they described as clarifying intent. The defense team appeared visibly anxious as the session opened, whispering among themselves and filing objections at an unusually rapid pace. The breaking point came when prosecutors announced they were submitting a previously authenticated email into evidence. At first, the defense objected immediately, before the document was even displayed. That alone raised eyebrows among legal analysts. In federal court, objections before reviewing evidence are rare and risky. But Trump's lead attorney did not stop there. He demanded an immediate sidebar with the judge, claiming the evidence was fabricated. The judge granted the sidebar. What was supposed to be a quiet legal discussion quickly escalated. Within seconds, raised voices could be heard across the courtroom. Reporters described the moment as electric. The judge warned the defense attorney to lower his voice. He did not. Instead, he accused the prosecution of manufacturing evidence to frame his client. At that point, the judge ordered a recess and had the jury removed from the courtroom. That decision alone signaled how serious the situation had become. Federal judges do not remove juries lightly. When they do, it usually means the discussion that follows could permanently affect the trial. Once the jury exited, the courtroom doors closed, and the real confrontation began. On the record, Trump's lead attorney made a stunning accusation. He claimed the email being introduced had never existed in any prior document production. He insisted his team had conducted a thorough review and that the prosecution was committing fraud on the court. He demanded an immediate mistrial. The judge asked a direct question. "Are you accusing the prosecution of fabricating evidence?" The attorney did not hesitate. "Yes," he said. "Absolutely." That single word changed everything. The prosecutor stood and responded calmly. She informed the court that the email had been produced months earlier, in September, and was clearly identified in the production index. She cited the exact item number. Then she delivered the blow that froze the room. The defense itself had referenced the same email thread in one of its own motions. The prosecutor handed the judge a copy of that filing. It showed that Trump's legal team had not only received the email, but had used it strategically while omitting the most damaging portion. The courtroom fell silent. Observers say the defense attorney's face turned red. Instead of retreating or clarifying, he doubled down. He accused the prosecution of altering the email after production. He claimed it was a setup. He raised his voice again, now shouting that the court was complicit. The judge issued a direct warning. "Lower your voice. Sit down." He refused. He said he would not be silenced and that he was prepared to go to jail to protect his client's rights. At that moment, the judge formally held him in contempt of court and ordered him to comply immediately. He did not. The judge turned to the federal marshals and issued a command that stunned everyone present. "Remove him." 2 marshals approached the defense table. As they did, a second senior defense attorney stood up and began shouting as well, claiming the removal violated Trump's Sixth Amendment right to counsel. The judge did not hesitate. "Him too," she said. Both attorneys were escorted out of the courtroom, still shouting as they were removed. One reportedly yelled that the trial was a kangaroo court. Another claimed the truth would eventually come out. At the defense table, a junior attorney remained seated, visibly shaken and silent. He had not been prepared to lead the trial. He had not conducted key examinations. And now, without warning, he was all that remained of Trump's defense team. Legal experts say what happened next may be even more damaging than the ejection itself. The judge placed her concerns directly on the record. She referenced the duty of candor attorneys owed to the court. She noted that making factual claims later proven false is not a strategic error. It is an ethical violation, and she warned that bar complaints and sanctions were likely. This incident did not occur in isolation. Observers immediately drew parallels to a growing pattern involving attorneys in Trump's orbit. Once respected lawyers have seen their careers collapse after making unsupported claims in court. Disbarment, massive judgments, and criminal referrals have followed. Now, Trump's current trial lawyers appear to be joining that list. From a jury's perspective, the damage may already be done. Jurors were escorted out before the worst moments, but they witnessed the tension, the objections, and the abrupt removal of counsel. Legal psychologists note that jurors often interpret such behavior as desperation or concealment, even if instructed otherwise. And for Trump himself, the consequences are severe. Replacing senior trial attorneys mid-proceeding is extraordinarily difficult. Any new counsel would lack familiarity with the evidence, the strategy, and the tone of the courtroom. Asking for a continuance could signal collapse. Proceeding without experienced leadership could be catastrophic. Even worse, this incident raises questions about whether the defense intentionally escalated the situation. Some analysts believe the meltdown may have been an attempt to provoke a mistrial. If so, it failed, and instead handed the prosecution a powerful narrative of misconduct and instability. As the court prepares to reconvene, one question hangs over the case: was this an uncontrollable outburst, or a calculated gamble that backfired in the most public way possible? When the courtroom reconvened after the ejection, the damage was already irreversible. Even without the jury present during the most explosive moments, the structure of Trump's defense had collapsed in real time. Legal analysts agree that losing senior counsel mid-trial is one of the most destabilizing events a defendant can face, especially in a complex federal case. The remaining junior attorney was left in an impossible position. He had not delivered opening arguments. He had not conducted the critical cross-examinations. He had not shaped the overarching defense strategy. Now, he was expected to carry forward against an emboldened prosecution, a visibly frustrated judge, and a jury that had just witnessed chaos erupt from the defense table. The judge immediately addressed the issue of representation on the record. She made it clear that the attorneys were removed not for advocating aggressively, but for refusing direct court orders and making demonstrably false statements. She emphasized that the court would not tolerate accusations of criminal misconduct without evidence, especially when the record contradicted those claims. This distinction matters. Judges expect heated advocacy. They do not tolerate defiance. Within hours, legal ethics experts began weighing in publicly. Former federal prosecutors described the conduct as career-ending. Bar associations take an especially hard stance on violations of the duty of candor, and the transcript alone may be sufficient to trigger disciplinary proceedings. If contempt charges are pursued, the ejected attorneys may need to hire a criminal defense counsel for themselves. For Trump, the consequences extend far beyond this single incident. Juries are instructed not to draw conclusions from attorney behavior, but decades of research show they do. When defense lawyers appear panicked, combative, or deceptive, jurors often infer weakness in the underlying case. The visual of lawyers being escorted out by marshals is not something a juror forgets easily. Adding to the pressure, Trump reportedly attacked the judge online during the lunch recess, praising his attorneys and accusing the court of bias. Legal experts warn this could worsen the situation. Judges closely monitor external commentary during trials, and public attacks can be interpreted as attempts to influence proceedings or intimidate the court. There is also growing speculation that the meltdown may have been a strategic miscalculation. Some analysts believe the defense hoped to force a mistrial by creating an incident severe enough to taint the proceedings. If that was the goal, it failed. The judge did not declare a mistrial. Instead, she asserted control and documented the misconduct in detail. That documentation may follow the defense for years. Future attorneys may be reluctant to represent Trump, fearing reputational harm or ethical exposure. Several major law firms have already declined involvement in past cases for similar reasons. The pool of experienced trial lawyers willing to take on such risk continues to shrink. Meanwhile, the prosecution gains a powerful advantage. They now control the narrative, calm, methodical, and grounded in documented evidence, contrasted against a defense that unraveled under scrutiny. Every subsequent argument from the defense will be filtered through that lens. Perhaps most damaging of all is what this signals to the jury about credibility. Trials often hinge not just on facts, but on trust. When lawyers are caught contradicting the record and responding with outrage rather than explanation, the trust erodes rapidly. This incident will likely be cited in legal textbooks as an example of what not to do in federal court. No matter the outcome of the trial itself, the ejection of Trump's lawyers marks a defining moment, one that reshaped the trajectory of the case and reinforced a fundamental rule of the justice system. No attorney, no matter how powerful the client, is above the authority of the court. What began as a high-stakes legal defense ended in a public implosion, and the consequences are only just beginning.